You're now live.
I'm now live. Jolly good. I think I'm anything but live actually. Right. I think we were still looking at freedom of trustation, etc., and we were looking at Alderney prior to the 1st of January 2016. And we were going to have a look at, well, I don't really mind what we look at. We can have a look at immovables first and then movables, or vice versa, whatever you all like. Let's do immovables. Alderney Land and Property Law of 1949.
We're on
6.1. Okie dokie. So, I don't know whether, you're eating at present.
No, I can talk about Dwyer.
Yeah.
So, Dwyer applied in Alderney right up until the 1st of January 2016. It is the right of a widow and a widow only to a usufruct or life enjoyment of 1/3 of the real estate of her late husband. So it's not hers, it's only a life interest, but she can either occupy the property or rent it out and take the trouser of the rent. And the right arises simply by operation of her marriage and the death of her husband. It is not subject to the qualifications that you get with the right of the widower that we've discussed before. And as I say, if you look at old Guernsey houses and old Alderney houses, you will see that there is the 1/3 of the house which looks different, and that's where Grandma used to live.
And it did exist in England prior to 1921.
Did it?
Yeah. Dower and Curtsey, which were very similar to, similar to this.
Right.
That's right. Yeah.
Now she's entitled, under the customary law, this right existed even if she were to remarry. And again, so that's different under the rights afforded to her by Section 3 of the 1954 law.
It changes in that.
For Guernsey.
Yeah, it does.
But we're just talking about.
We're talking about Alderney prior to.
I'm just confusing.
I put impediments, but I don't know. It's customary law, so I'm not sure. I think some of those impediments will still be enforced. Things like if she kills her. In fact, there's a case on that. Pool.
Yes.
Yeah.
So you're not allowed to claim your right if you do in your husband, no matter how irritating he may have been. You can voluntarily waive it.
Yeah. Or you can actually agree a lesser amount as well, can't you?
You can agree to a lower. If you've got a husband with oodles of real property, you might agree to take a smaller share.
Yeah.
We've got here that the failure or lack of opportunity to consummate the marriage is an impediment.
I don't know whether I agree with that because I mean, it's from something else, and I think that was the condition throughout the whole of Norman.
Yes.
Norman France,
so
but
if it's in Terriat, then it would definitely apply here, as we know. The lack of opportunity to consummate, I mean, that would be pretty unfortunate, wouldn't it? That she snuffs it on her wedding day, or he snuffs it on his wedding day. He chokes on the wedding cake.
A divorce, clearly, I don't know whether I think that's an impediment.
So I'm not sure if that would apply if they've just separated. So Terriat says that it is an impediment.
What, divorce?
No, a divorce would be, but separation.
Without a property adjustment?
Without a property adjustment, if they've just decided to live apart.
Yeah.
I'm not sure.
No, I'm not sure.
Let's not dwell too much on that because it now doesn't exist.
Is that what you mean by the divorce through no fault of their own?
Well,
divorce of non-marriage, the Christian law was that the wife is divorced through no fault
Yeah, his adultery.
Yeah.
Yeah. Because you had to be a good girl, I suppose.
Under customary law. But
Under
I
customary law, but
suspect-
not now. No, not.
I suspect if you were divorced, you know, in the 20th century, you were to have a financial arrangement that said you no longer have any rights, you couldn't then invoke your customary
Yeah.
law.
No.
Right.
Where she leads a debauched life. I love that.
Yes.
Or abandons herself to plaisir charnel. Sorry.
I'm not sure. Yes,
Stop.
I'm not sure that modern day.
I agree.
She would lose the right.
No, I agree. I think customary law would
I think it's moved on.
evolve. Yeah, would interpret things differently.
It's moved on a bit.
Yeah. But I do like this.
Yeah, indeed.
Yeah, I think it's brilliant. I love it. I absolutely love it.
So under customary law, the widow had to assert her right, but that's not what the 1949 law in Jersey says. In Alderney says. It simply is a right that is afforded to her. Dower over down not being allowed. So this is a situation where you have the wife marrying her husband. They've got a son who marries. The property is owned by the husband, and he dies. So the son would inherit the property subject to mum's inheritance, and then he dies. You can't have his wife claiming a dower over the dower that mum has.
Yeah, you've got to wait till mum
You've got to wait
dies
until mum pegs it first.
before the daughter-in-law
Has
her dower.
But she is entitled.
Oh yes, absolutely, she's entitled to it.
You can't boot
you
your
can't have both in
mother-in-law
together.
out.
Or,
Yeah.
I think that's a customary law. Mother-in-law. It's not always a comfortable one.
It existed for many centuries.
Absolutely.
Indeed. So Frank Bovage, we've already talked about. This is the right only given to widowers, and they, as opposed to a third of the immovable property, they get a right over all of their wife's immovable property, but only if there has been a viable child purchased. And unlike dower, this is a right which, if the widower remarries, loses. So, of course, he would have been foolish to remarry. Right, so the will of movables. So what I wanted to say about immovables in Alderney is subject to those rights, the right of dower and the right of Frank Bovage. Since 1949, at least, you can leave your Alderney real property to whomever you choose.
I'm not sure I think that.
It's. I think they were trying. They modernised, as you know, they modernised Alderney's law a lot after the war, because unlike Guernsey, Alderney was completely evacuated. When they went back, it was unrecognisable because of the work that the Germans had done. Oh, they moved. I mean, they demolished properties. They moved boundary marks. It was a completely
Oh, I didn't know that.
So then it's interesting. So what happened was there was the states when after the war, they tried to put boundary markers down where they thought the old boundaries were according to the old maps, and there was lots of people moving boundary markers in the middle of the night and all that sort of stuff. But they were trying to modernise Alderney's legal infrastructure in the aftermath of the Second World War. And so their law, the Alderney law, is completely different to both customary law and also the law that applies in both Sark and in Guernsey. So immovable property, you can do what you like, subject to Frank Bovage and Dower. The will of movables in Alderney. Now, this is the bit where if you were to explain this to somebody, they wouldn't believe you. This is now movable property. So we mentioned before the Married Women's Property Law, right? So in Guernsey, that was introduced in 1928, and before then, there was a piece of legislation called the Loi relative au meuble des pères et mères of 18 something, and effectively it had this provision that we see in Guernsey now, but of course it made no mention of the rights of a widower to any property of his wife if the wife dies first. Because if the wife dies first, all of her property is his. Yeah, before we had married women's property law, it all belonged to the husband. So the law only made provision for how to look after the widow when her husband dies. And this was a piece of legislation that applied equally in Guernsey and in Alderney. So Guernsey introduces in 1928 the married women's property law, and somebody 2 years later notices that the inheritance laws don't seem to have caught up. So they revoke the 18 whatever it was law. I can tell you what the 18 whatever it was
72.
law. 1872 law. But the 1872 law applied in Guernsey and in Alderney, and the married women's property law was only being introduced in Guernsey. So what they did instead was in 1930, they introduced the law that we've already talked about, which is third, regardless of who goes first. And in Alderney, they reintroduced in 1930 the 1872 law. So the 1872 law says if the widow, if the husband dies, then his wife gets a third, the children gets a third, he can do what he likes with the other third, and makes no provision for what happens if the wife dies first. And if in Alderney, if the husband died without a widow surviving him, then the children get half, and he's able to do what he likes with his other half. And again, it makes no provision for what should happen if husband dies, if wife dies, leaving only husband and children, because it doesn't matter, because all of wife's property belongs to husband. So then in 1949, they introduced the married women's property law when they are reforming their legislation. But they don't get round to replacing the 1872 law that they reenacted in 1930. So we had from 1949 until 2016 the provision that a husband had no rights whatsoever to share in his wife's estate, and the wife's estate was distributed to the children regardless of the existence of the husband, which was just potty. And they allowed that situation to continue for 60 plus years, and then they changed it in 2016.
So what's the practical effect if wife dies with the husband, children inherit with no regard to having to give provision to the husband?
Correct.
Yes.
What an intestate.
No, this is all testacy. This is all testacy.
Correct.
Yes.
Correct. And you would have to have a will, obviously, because otherwise it gets very messy for the poor old husband. But it meant that
the children, they can
correct. But it meant that the children were always entitled to half of mum's estate, regardless of whether dad was alive or not. So if you wanted dad to have more of the estate, that was tricky. So that is the peculiar position under Alderney law.
So if you put it in joint names, then the provision
Yes.
As in Guernsey, there was a trust provision. So let's just say you've got children who are special needs, but not. You have concerns about your children having access to their share of the leisure team. Maybe they are minors. Maybe they are wastrels. Maybe they have married unwisely. So both Guernsey and Alderney had legislation that said you could actually put their share of the leisure team on trust.
Guernsey and Jersey.
Sorry,
Yeah.
Guernsey and Alderney.
Alderney.
Forget Jersey.
No, because Jersey doesn't allow that.
No. But in Guernsey and Alderney, you could put this leisure team on trust. But it was a very limited trust. So you had to give, come what may, you had to give them the income that was generated by their share of the leisure team. And on the death of the child, the trust fund formed part of their estate.
Could you use a tutel instead?
You could use a tutel if they were minors.
Minors, that's what I meant, yeah. And a curatorship, I presume, if they were
infirm or unable to manage their own affairs. But if they were just a bit thirsty, as we have, or correct, correct.
Yeah.
Now, so what used to happen is if you really loathed your daughter-in-law or your son-in-law, you'd put your child's share on trust, so that would stop them having immediate access to the capital. But if they outlived your child, and if your child left a will in favour of the husband or their husband or wife, then they would get their hands on the capital eventually.
So if you have 500,000, you put that in trust to avoid the charge of the capital, but the income on the capital.
Yeah.
If they survive the terms of the trust, then that just continues forever. But if child dies, then that trust.
The trust fails, and the capital is part of their estate.
But in theory, it will just continue on the terms of the trust until they're there.
Yes. Now, again, one of the advantages of living in a customary law jurisdiction is you can make it up as you go along. The practice developed of if you wanted to advance the capital of the child's leisure team that was held under the terms of the 1890 and 1893 trusts, you could do so because you were really just giving them what was due to them already.
So if they were reformed or had divorced.
Yes, absolutely.
Or
the things facts change.
Yeah. So although the law doesn't say it, you could put in your will, for example, and I'll hold it on trust, their leisure team hold on trust until they're 25 or 30.
And then you just distribute the capital.
Correct.
Yeah.
Really sorry.
No such thing as a stupid question.
Who would it be designated who would hold the trust?
Yes.
Would it be professional trustees, or because the estates weren't worth that much? Who would?
So,
would it have
if you think about when these pieces of law were introduced in 1890 odd, there wasn't a trust industry. So you might have appointed your advocate as your executor and trustee. You might have appointed your accountant or a business partner. But you might have, it might have been a trusted friend or family member.
And going forward, even though the trust industry is built up, could that still be the same?
Yeah, absolutely.
So it could be a
Absolutely.
trusted friend. So you probably still want them.
So we'll look at that tomorrow. But you can, if you had a trusted friend who was doing it, you would give them the maximum indemnification
Yeah.
allowed under Guernsey trust law, which is everything except fraud, willful misconduct, and gross negligence.
So this provision to put it into trust, what legislation is that? This is the-
There's an
That is under-
1890 ordinance in Guernsey, and it's an 1893 Loi supplémentaire à la loi de succession. But it's 1893 is the ordinary one,
Yeah.
and 1890 is the Guernsey one. But they're the same pieces of law.
So it's not, it wasn't like a modern maxim to try and get around it.
No. So people who are saying, oh yes, no, trust didn't exist in Guernsey until 1989. then-
Because this provision to put in legislation on trust is from old legislation.
Yeah. Okay.
Post 2016.
Easy peasy. we've
Yeah,
just done it.
we've done it all.
Same as Guernsey.
So we're not going to do that again. Sark. Okie dokie. What do you say about Sark? Immovables. Yeah. Oh, gosh, where do we start this one? I think the thing that hit home when I read notes on Sark, first of all, was that you can't have undivided shares. In immovable property. So therefore, property. If you've only got one property, it's got to devolve to one person. If you've got more than one property, then you've got two properties can devolve to two people.
Yeah.
And I assumed, maybe wrongly, that was because it's a very, very small island. So I don't think that.
No,
so
no,
you
it
do
is.
not want division and subdivision and further subdivision of land there.
Correct.
That's correct, is it? Yeah, that's
So-
what I assumed was the case.
Yeah, so basically, until the 1999 law reforms, which were forced on the island by you know who,
So who's you know?
I can't say because one of their law firms is represented in the Barclay brothers. Indeed, but yeah.
Oh, they pushed it. Did they
It
push
is
it
common
through
knowledge.
legislation? Really?
Against the will of most of the island.
Oh, right. I didn't know that.
However,
I knew that there was
um,
legislation.
that may be my clause. I don't want to get strictly from Gordon. So.
Oh God, yes, you represent him. Just like, that's a big deal.
No.
Oh.
He knows. We've discussed this. Anyway,
Right.
so before 1999, the customary law of Normandy applied with some amendments in Sark. So it was impossible to do a will of real property. Impossible. Effectively the intestate regime was the only regime that was available, and in effect, your property devolved to your oldest son. So in 1999, the law was changed. Now, since the 16th century, Sark has had 46, I think, tenements, which are these pieces of land. And the constitution of the island says that these pieces of land shall remain indivisible. Mind you, the constitution also says that if you own a tenement, you have a pew in the church, and you must pay for 2 musket men to protect the island from pirates. That latter rule seems to have fallen into disuse.
Customary law.
Yeah, indeed. And you're quite right, but the reason being the island's far too small, the units would be far too small to be economically productive. So the tenements cannot be divided. But there are actually other bits of real property in Sark which aren't tenements, and there's also long leases in Sark. So it's not true that you can't divide up land. You can, but you have to be a bit clever about the way you do it. But as from 1999, subject to the rule, if you can't divide a tenement, you can decide which of your heirs are going to inherit that tenement. It is now gender neutral. There is no distinction between legitimate and illegitimate people. And so Sark was the first part of the bailiwick where that distinction was abolished. And that may have something to do with the fact that there is no divorce law in Sark. So if you don't like your spouse anymore, you just move away from each other and have children with somebody else.
Did you know this? You're doing family law. Did you know that?
I believe it is a myth, but a myth that is popularly held that in Sark you can still beat your wife with a stick, provided it is no thicker than your thumb. Yeah, I wouldn't rely upon that if you were into domestic violence. Anyhow, so you can choose amongst your descendants who is going to inherit, but if you have descendants, your heir must be one of those descendants. If you don't have any descendants, then you can pick any natural person, not a company. And the reason being that the owner of a tenement must swear an oath of fealty to the seigneur, and of course a company cannot make an oath of fealty. And if you have no descendants, you can now put your property into trust, which is something that was absolutely something you couldn't do before, in order for your trustees to sell your tenement and then divvy up the cash. The 1999 law abolished the rights that we've just been talking about of Dwyer and Frank Bovage, and introduced, as in Guernsey, a new right for the surviving spouse. And it was a similar right, that it was 1/3 of the property of the deceased spouse, which could be exercised over whichever part of the property that the surviving spouse wanted to. Then we talk about wills of movable property in Sark. Not movables property. Oh, it's a typo.
What's that?
Wills of movables property.
Oh.
So the succession personal estates of married persons Sark law 1975 effectively provides for the same rules as in Guernsey in the 1930 law. So it's third, or a half-half. There isn't, I think, in Sark the trust provision. So there's no equivalent to the 1890 or the 1893 law. Want to talk about the avoidance of forced ownership?
Better do a bit on avoidance. Depends what you're talking about, but movables or immovables, really. Trouble is, well, movables change your domicile. That's one way of doing it, I suppose.
Yeah.
Or change the nature of the property, I suppose, might be another way of doing it. I don't know if you agree with that.
Yeah.
The problem is, if you change the nature of property, you're caught between a rock and a hard place sometimes, because you then get caught by the immovable regime. But that's one way of doing it.
So, for example, if you wanted to prefer one of your children over another, it would be possible for you to take your personalty, your large bank account, and transform that into real property. You buy a house with it. That real property will be subject in Guernsey and then to the 1954 regime, where I can pick which of my children I want to leave it to. So if I want to prefer one child over another, greater than the extent of the portion of his money that would allow me, then that's one way of doing it. joint
Yeah,
accounts is
Yeah.
another obvious one.
yeah. Can't think of much other than that. Can you?
Well, you could create a trust in Jersey. So if you were to create a trust in Jersey, then both Guernsey and Jersey trust law have firewall provisions which protect Jersey trusts from the application of foreign rules of forced heirship. And of course, Guernsey.
But you'll be subject to Jersey law, forced heirship, won't you?
No, because they would only apply to Jersey domiciled people.
Oh.
So if you're a Guern and and everything
Yeah,
about you is that you're a Guernsey family, but you want to create a trust so that your estate devolves in accordance with the way you want it to devolve, you create a Jersey law trust. You give the assets to trustees in Jersey, and then your disappointed heirs would have to go to Jersey to say, this trust does not respect my rights as a matter of Guernsey forced heirship.
Yeah.
Whereupon the Royal Court of Jersey turns around and says, so what? Because our law, Article 9, protects Jersey trusts from the application of foreign rules of forced heirship, and Guernsey, you are most definitely foreign.
Was that happening in practice?
Yes.
Yeah, you do that a lot, I'd have thought. wouldn't you?
Yes. And similarly, you have Jersey people setting up trusts in Guernsey. Another thought that some people thought worked was you would make lifetime advances to your preferred child, but that does not work.
No, that doesn't.
And it doesn't work because when you work out the leisure team, you take into account lifetime advances.
Mm.
Now, to the extent there's an evidential issue as how on earth do you prove how much money your late father gave your useless brother? But if you can prove it, you can say, well, you have to take that all into account. Funk and Koshenko, which is it's the estate of Krombach. So it sounds as though everybody's German, but they are all Guernsey people. And in that case, the then bailiff, Carey, was satisfied that you do take into account advancements. Now, the question nowadays is what is an advancement? If I'm paying for your school fees and you're my child, is that an advancement? Probably not. If I buy you your first house to help you set up in life, possibly yes. If I pay for your apprenticeship,
Definitely,
then
definitely not subject. Sorry.
Yeah.
So
Yeah.
what is a normal birthday gift or Christmas present as opposed to an advancement? If I'm very generous at Christmas and birthday times, is that an advancement? These are all issues that I'm afraid we don't know the answer to.
But presumably, if you're the child arguing that somebody has an advancement, you've got to be pretty sure. Or
You've got to be pretty sure.
You've got to show.
the other way.
Yeah.
Yeah.
What about that diamond necklace that Dad bought you when you were 21? Yeah.
So,
Yes.
Yeah.
Yeah.
Immovables.
So immovables, there's not a lot you can do about that because an immovable you can't move because it's immovable.
Sell it.
So you can sell it and then transfer it into cash, but then you in a different regime.
Transfer it to a company.
You could do that, but then you
I
could
know,
have
you
retray.
Yeah.
So retray was. Do you know what retray is? You know about retray? So this was if you were okay. So retray, if you are the heir of somebody and they sell some real property, you have the right within a month to purchase from the purchaser that real property on refunding the purchaser his purchase price and costs. So you're basically so the purchaser cannot be in any worse position. But it's a way of, this goes back to this notion that your real property is somehow sacrosanct. So if your mum or dad has just sold the family home that's been in your home for generations, you can buy it back to keep it within the family.
That's back on that.
Yes.
Yeah.
When's it go?
Can't remember.
No,
10 years ago, 15 years ago.
No, it's only just gone in samples.
In samples, it's gone.
Yeah, I can't.
Don't know. I'll come back.
Don't know, I can't remember. But
That's a question for next week.
Yeah,
In the
next week.
conveyancing
Yeah.
paper. It is in the notes, but it's.
Yeah, it is in the notes. Okay, and I think that is it on testamentary freedom, which gives us an hour and a quarter to do intestacy. I won't go through any past questions yet because I want to do intestacy next. Okie dokie. You can, I can't remember what comes in. You can have a look at contents of a will yourselves, and you can have a look at, I think that's.
We've talked about the capacity to inherit.
Yeah,
we basically have to be alive.
Yeah, we've talked about some of this stuff already. And I think there's stuff on construction. Again, yeah, you can read that. I don't think it's difficult. I don't know what that. It's pretty easy stuff.
So basically, you construe a will to try and give effect to the intentions of the testator as appears from the face of the will. If there are mistakes in the will, the courts in Guernsey and Alderney have said that they can rectify a will. And unlike in England, where you can only rectify a will within 6 months of the date of the grant, probate, the Guernsey and Alderney courts don't have any such limitation. So provided you haven't sat on your hands, we had a case in Alderney where we rectified a will 22 years after the testator died because the drafting anomaly had only just come to light. It was interesting because the then bailiff was the author of the said will. I had to take a witness statement from him.
Okay.
Well, of course I meant this. That was ridiculous.
And that continues to remain.
Correct. Yeah, and lots of wills and trusts.
Okay, let's move on to intestate succession because I think we do need to cover that today. Otherwise, we've got a bit of an uphill struggle tomorrow. Because I do want to go through past papers with you as well as trying to do trusts tomorrow. So, general principles. I don't know whether we can whiz through these general principles, some of which are relevant. Yeah, probably all of them are relevant, actually, I hate to say. Direct and collateral succession, let's try and do that very quickly. Direct successions are where you have descendants or indeed ascendants. Collateral successions are where you haven't got sort of a direct line going up or down. Does that make sense?
So direct succession is you leaving things to your children or your grandchildren or your parents or your grandparents. It tends to be very easy, particularly to your children and then to grandchildren. We'll look at that in a minute. As a result of that, most questions are about collateral succession, which is what happens if you don't have issue, or if those issue predeceased the decujus. So that's an example. We won't do that now. We'll come on to that when we talk about representation. But if you're wondering, who are Bert's heirs in this, that would be a collateral succession because he hasn't got any issue and there are no ascendants either.
Okay, we'll come back to that and have a look at it. Applying it to questions. Half-bloods and whole-bloods. Well, what can I say about that? There's a little example there. Now, these, I must confess, these examples didn't quite work out as I wanted them to work out because they're on the wrong lines, etc. So if you have a look at the example, it should be Pierre marries Julia, and Julia then marries Hubert, who then marries Sophie. There are 2 children of Pierre and Julia's union, Clara and Celine. Sorry, that should actually be all of
Yeah.
it. Yeah. Then we've got Robert and David are born of Julia and Hubert, and Christophe and Marie of Hubert and Sophie. So that's all you need to know.
Yeah.
Oh, so did I not? What did I say? Did I say it right or wrong? Sorry, that's me. No, it's Christophe and Marie. Does it look like this?
Okay, so Celine, yeah. I was wrong, you were right.
I think.
So Celine,
We can work with yours, as long as I remember. It's all right, yeah, no, I'll just change my name. We'll use yours, it's absolutely fine.
Doesn't matter. We can work with those names. Right, what we need to note then, Clara and Robert are, I suppose, brother, sister of whole blood. David, Christophe, I think is the next one, brothers of whole blood. Celine and Marie are brother, sister, whole blood. And therefore, if you look at, let me get this right now, Robert and David, half-bloods, gosh. They are same
uterine siblings of the half-blood, which sounds like it should be a Harry Potter book.
It does, doesn't it? Yeah, it's brilliant. Clara.
Correct.
Yeah.
So, sanguine is if you've got the same dad, and uterine is the same mother.
And then I think you can work them out for yourself.
And Clara and Celine are not related at all.
Okay, Clara, David are related, half-blood, mother again, isn't it? Between again, I think you might say. Christophe, Celine, half-blood, and this time it's consanguine, I think you might say. And you can work the rest out, all muchness those. Okay, so we'll come back to that. Computation of degrees, yes. Yeah, sure. Yeah.
Well, depending on whose estate we're talking about, you might be related or you might not.
I think the only place, correct me if this is wrong in Guernsey, the only place where it's going to make a difference is where you're inheriting from your brother stroke sister, or half brother stroke half sister. Does that make sense?
I can see what you mean when you work out who the rest of that should be fairly obvious.
Yeah, but I think it's only you will classify a sibling by half or full blood to the brother sister. Does that sort of make sense? Now, yeah.
So I'm just thinking about this example. If it probably doesn't matter, does it?
I don't think it matters. It doesn't matter when you're on the directs, does it? And the direct succession. It's the question is whether, let's kill off Pierre, Julia, Hubert, and Sophie in this example, and put Clara as the decujus. Does that make sense? Then Robert will be. Right. Robert's the whole blood, and everyone else is the half. Oh, hold on a second. No. David's of the half blood, and what's his name? Christophe's of the half blood, and then Celine and Marie. Forget about those. Ain't gonna get nothing, anything. So the question is whether David and Christophe will take half of what Robert will take because they're of the half blood rather than whole blood. And I didn't know the answer to that.
No, I understand.
When you're looking at Some of the things like I remember
Doesn't matter.
will depend on whether your mother or father.
Correct.
So does that matter when you're
It might
half
do.
bloods if you're from your brother or
It
your
might.
mother?
It might do.
I'm not sure you get that.
But no, it doesn't, does it? Because you're either from that line or you're not from that. So if for example, yeah. So if for example you're taken from Julie, it doesn't really matter. It's whether you've got a direct succession there, not whether you've got. Does that make sense?
But
So
let's say that Clara. Well, let's not kill off Clara. Let's
Clara
clear
then.
off. Let's
Clara, okay.
Let's kill off David.
Okay.
And you've killed off all of the parents'
Yeah,
generation.
let's kill the parents off. Yeah.
And David had a property that he inherited on Julie's death.
Yes.
As a result, so he
Yeah.
has got a prop maternal. I think that's when it might matter. I think that property is likely to go to Christoph, Robert, and Clara, or Christoph.
No. Christoph.
We go to right. Well, Christoph's dead. We're going to kill off Christoph, right? So I think that would go to Robert and Clara. It wouldn't go to Marie and Celine because it's a prop maternal.
But that's just because it's a prop maternal, not because they're whole bloods and half bloods in society. You just
No, but I'm just-
the prop.
I am. I'm just saying,
Yeah.
when is it different? Because they have the same
Yeah.
mum.
Yeah. But what happens if you have an arcade?
Yeah.
Or a movable, and we kill off? I don't really know who we kill off. I want all the parents.
If we kill off David,
Well, kill off David.
and Christoph's already dead.
Hold on.
If it's an Ake, I don't think it matters.
No, it's not going to go into quarters, is it? If Christoph, if it's an Ake, it's going to go to. Yeah, it doesn't work. You've got to kill off somebody like Clara for it to get half blood in there. If you kill off Clara, and it's an Ake or a movable, doesn't really matter. Then the question is whether, hold on, Robert as a whole blood takes more than David and Christoph of the half blood. Does that make sense?
It does make sense. But
So
I'm sure I know the answer.
No, I haven't got the
need to
answer
think
to
about
that.
I
it.
probably better when you was really after.
I couldn't actually, because
I
I
think then, to answer your question, I think there may be circumstances where it is relevant that you and I are siblings with the same
Yeah.
mum, as opposed to you and Paula, who are siblings from the same dad.
and it will depend on the prop.
It
whether
will,
it's-
it will
it's a
depend
prop
on the
maternal,
property
yeah,
we're talking about.
Yeah. But I don't know what happens when you're going across, if that makes sense, inheriting on an Ake or a movable, and you've got half bloods and whole bloods there. I don't know whether the whole blood takes twice the amount of the half blood.
No, I don't think so.
No,
We'll
it's all
come
the
on to
same.
that.
Okay, that's absolutely fine. I didn't know. I didn't know the answer. I thought the answer anyway. But anyway, computation of degrees. Oh yes. I know how to do it. I find it very difficult to explain it, I must confess.
You want to go?
Yeah, go on. I don't know if you're going to be any better.
Sounds
You
okay.
probably will be better at explaining this to me because as I say, I know how to do these things.
So there are two ways of doing it.
But you've only really got to worry about one.
Yeah. So we do the canonical. You might need to know this. Sometimes I have to the question. So we'll have lots of people. A, B, C, D, E, F, G. Each line is a generation. So this is a very long-lived family. There are two methods of working out degrees of relationship. Canonical method, which is the one we use, or the civil method, which we do not. So the canonical method, you identify the person who is the closest common ancestor of the claimant. Right, let's just say that we're talking about the estate of D. and we're trying to work out how many degrees of relationship there are between D and your client, who is E. You work out that, well, let's say your client is C. There are 2 links up to the common ancestor, from D to B, B to A, 1, 2. And there's 1 link going back down again from C to A. In the canonical method, you just measure the longest of those lines. So C and D are related to the 2nd degree. E and D are also related to the 2nd degree, because you just count the longest line, and both of those are 2. If your client was G, that would be related to the 3rd degree, because you go 1, 2, 3, 1, 2, 3 degrees of relationship. The civil method, the only difference is you count both lines
And add them together.
So D and C are related in 3 degrees of relationship, 1, 2, 3. E, 1, 2, 3, 4. G, 1, 2, 3, 4, 5. But you only need to know that to know that there is a difference. And all we do is count along the line.
Yeah. Which is easy.
Yeah.
Next thing, hold on. Props, case and movables. I think we've done that, haven't we?
We have talked about what they are.
We haven't applied the law yet, but we'll do some application in Hawaii. And representation, which sort of at times makes the counting of the generations a bit fallacious, doesn't it? Because people step into each other's shoes.
This is an example about. So we're talking about the state of Bert. So let's just mention first that with a prop, you always had representation. And what that means is, if I am the heir and I'm dead, my children step into my shoes and together represent me. So that is always allowed with prop, and it goes up to 7 generations. But in reality, who the hell has great grandparents still around?
That's actually customary law.
Yeah.
Despite the fact it's 7 generations.
With Ake, you only get representation, and this is bizarre, but you have to believe me. You only get representation where a sibling of the deceased joins in the estate.
They've got to be alive and kicking.
They've got to be alive and kicking.
If they're dead, it's no good. Which is a bit unfair, but there you go.
So in this example,
have you killed Charlie and Donald Duck?
Yes.
Is that what those little things?
The little crosses.
Oh, I didn't know that. Is that what you're doing, Guernsey? Is that the...
Well, that's what I do. I don't know, but it's probably not very PC now.
It's
a Christian. It's probably a Christian symbol, which may offend somebody.
Oh, that's offended. Yeah, that's offended me.
Yeah.
Yeah.
So in this case, we've got we have Bert is the Decuja. I'm sorry if you're a Latin scholar, I've mispronounced. And Bert has not got any children. His mum is dead. In the first example, we will say that his brothers, Charlie and Donald. He is survived by his nephew, Emil. Sadly, his nephew Fred is dead. His nephew Guy is dead. He's got a great nephew, Isaac, he's still around. And his other nephew, Harold, is still And Bert had 2 items of real property. He had property in Pollock, which he bought, which is Derek Smith's now, and he inherited a field from his mum in Portugal on her intestate death. So that is, well, what are those 2 properties?
How would you classify the first one? Yeah.
Okay, yeah.
Okay. And the second one?
Correct.
What type? So did they say?
Yeah, prop was
Oh, sorry.
Yeah, okay. So dealing with a prop, representation is always allowed. So who inherits the field in Portugal? And in what proportion?
You don't have to really bother to look at the canonical method there because
You've got representation.
it's got representation, so you don't have to
means
bother.
that you look at dead people and you see who stands in the
They
middle
should.
of the dead people.
So he will step in.
Yeah.
And other lads will also be.
Yes.
Right, so if none of these people have been born and I asked you the question, and Charlie and Don are still alive, what would happen?
You get 50-50.
Yeah,
Correct, because they're
absolutely.
both related to the same degree of relationship, right? So it's 50-50 each. But now we've got these people in. So Emil takes Dad's share,
Yeah.
he gets
Yeah.
50%. What happens to the other?
Is
divided
divided
between-
by FGA. They
Well,
were.
Fred's dead.
Dead. Absolutely, yeah.
So we get 50%, 25%, 25%.
Yeah.
Right? Agreed? Now what happens with the shopping pot?
It's only permitted if the sibling of the deceased is alive, so we're not.
Okay, so we've got no representation.
So they each.
Well, if you haven't got representation, you've got how are you getting there?
So there is nobody representing Charlie and Donald. So we then look and you count the number of lines. The common
That's when it's important.
And closest relations are Emil and Haviland. So what happens is Emil gets 50%,
Yeah.
Haviland gets 50%,
And poor
and
Isaac.
Isaac gets an out. Now, if we were to bring Charlie back from the dead in a bizarre ritual, so he's now alive, and we ask the same question, who gets what in relation to, let's say now, who gets the farm, the field and farm. So it's a prop, you always have representation.
Charlie.
50%.
Yeah.
And 25.
25
Yes.
to 25.
Just Emil gets.
Emil gets nothing because Dad's still alive. You can't represent someone who's still alive. Right? And now who gets the property in the Pollock, the shop?
Charlie.
No, because you've now got a
No,
you've
but
now got a sibling
representation.
representing, joining in the succession. So what do we say about representation in that?
You can have representation.
You can have representation. So it's the same.
Yeah.
So it's 50%, 25%, 25%, and again, Emil gets now. You have to wait until Dad walks the village.
We'll do more of those. Oh, Pastouche and Partet, you've sort of done, I can't mention that the Pastouche
Yeah.
and Partet, they have done that already.
So you can either inherit because you represent somebody else, or you are the heir.
You mean when you're in terms of
In your own right.
Cannot observe through small.
Yes.
Yes.
Canonical. Yeah. So we in practice we use the Latin terms, but
Oh, sorry, I've used
no. But
the French. Sorry.
in we the customary law is obviously uses French terminology, but pastouche and pasturpes means the same thing, which means by branch. And the other one is per capita or partet, which means that you count the number of people. So when we were talking about there not being representation when Charlie was dead in relation to the poet, Emile and Haviland inherited the property partet or per capita because they were the people who were the closest heirs, and you count the number of people in the class and divide it by the number of people. When there's representation, Isaac gets a look in, and then it's a distribution either pasturpes or pastouche by branch. Does that make sense? Yeah. In wills, you will see people talk about pasturpes. You rarely see them talk about pastouche.
Where do you put that in the minute?
Oh, this is
Page, well, it's page 85, 10.7.
And now on to the specific rules of intestacy. Guernsey first,
Okay.
as ever, before 2nd of April.
So whatever, come what may, your surviving spouse has his or her Section 3 of the 1954 law, life inheritance. Okay, so you, life interest. You can't do anything about that. Subject thereto, if you've got descendants, the descendants just take it all.
No difference between props and
Yeah.
just one prop.
Prop in that case is only relevant when you have a collateral succession. So there's no distinction made between male and females. Equally, there is no distinction made between whole blood and half blood, provided that your half blood is descended from the same parent. Collaterals, brothers and sisters. So we've talked about the fact that prop, when you have prop, you have representation, and you only have representation for ake and personality. So the rules in relation to personality are exactly the same as they are for ake, where you have a sibling joining in the estate. Ascendants.
I mean, they knock each other out, don't they, if that makes sense?
They.
If somebody higher up knocks the others out.
So in this case, Charlie excludes Emile.
Yeah.
If Guy was alive, that would exclude Isaac.
So the brothers and sisters kick out the parents.
Brothers and sisters would, well, they do for a different reason. The brothers and sisters would knock out your nephews and nieces, but your nephews and nieces would knock out your great nephews and great nieces. Yeah. Under customary law, okay, it doesn't matter. So
if I'm not married with nobody,
yeah. Why? That's as an English person.
No,
that's what you think. No. So customary law, your ascendants can only inherit from the last of their descendants. So that's a pretty, as a parent, you don't want to be in that situation. No, it goes up the line. We're talking about Guernsey now. It's completely different in Alderney, and that's bizarre. But in Guernsey and Sark and customary Normandy, the aim is to push assets down the generations. They only go up as a matter of last resort. So a parent will only inherit if there are no brothers and sisters, no children, nephews, nieces.
That's right.
As far as you go down before you go up.
Yeah.
So you can only inherit from the last of your descendants. The other thing to mention is that when you look at prop, in parity of degree, they go to the side of the family that they came from. So your relatives on your father's side will inherit your prop paternal in preference to your relatives on your mother's side. They return to the side from which they came.
So a practical example would be
let me think of a family tree where that might be relevant. We've got dad, got mum, and let's say we've got granddad, that's spelled granddad, and we've got grandma, and we've got papa, and we've got nana. And we've got X. And dad died leaving a field. And X dies and hasn't got any issue. That property would pass to granddad and grandma, not to mum.
to take it back to
The right bit of the family.
To the father side of the family.
Half.
Would that make a difference if dad had a brother?
What, alive and kicking?
Alive and
Yeah.
kicking,
yeah. It would.
It's going to go to the brother.
Brother, yeah.
It goes to brothers and grandparents.
Because granddad and grandma can't inherit
What? Yeah.
until the descendants. Equally, if we killed mum off as well and we had two fields, one inherited by mum, one inherited by dad, then the fields would go, the proper maternal would go to papa and nana and not to granddad and grandma. But if you don't know which side of the family that prop came from and how that might happen, but then you prefer the father's side.
If you kill off Papa and Nana there as well with the mother's field.
Yeah. And there is nobody else.
And nobody else. Oh, what happens then? Sorry, I wasn't asking.
We've killed
off mother and Papa and Nana, and it was a maternal that came to X. Or what happens to it now?
And there are no other people on that side.
You'd hope so, wouldn't
I think it
you?
would go to uncle. If uncle's not around, it would go to granddad and grandma. This is why, incidentally, everybody in Guernsey keeps track on all their relatives. Oh yeah, in case cousin might snuff it, and you know, he might be in the estate.
Right. Okay. Didn't know that. So I think we're still working on immovables, aren't we? So we said collateral succession, brothers, sisters, ascendants, and then other collaterals.
Who would be cousins and remote.
Yeah.
So you can inherit within 6 degrees of relationship in Guernsey. If there are no heirs within 6 degrees of relationship, then it becomes bona vacantia to now the crown. It used to be the seigneur where you lived.
And then movables. I can't remember. I don't think we've done movables. Well,
We're 11.2 now.
Yes.
yeah.
So again, we're prior to the 2nd of April 2012. Going back to the CND picture, your surviving spouse, if you have one, gets his or her third. If you've got issue, they take 2/3. This again is consistent with the Norman idea of you pushing assets down the generations.
Because effectively you haven't utilised your portion.
What we're doing is we're giving that portion of disability to your
Descendants.
So in an intestacy, then children will get that as well. If you have no surviving spouse, but you do have children and remote issue, and remember that personality is dealt with the same as ACE. If you've got children, and maybe one of your children has died, but you've got grandchildren from that children child, grandchildren step into shoes. In a direct succession, you always have representation. The children get a lot. If you don't have any children and you have a spouse, you might think the spouse gets everything, which is unfortunately not the case. The spouse would only get a half, and the other half would go to your collateral heirs. So this is why it was particularly important for childless couples to have wills, because you might think, well, what's mine is yours and what's yours is mine, but no, half of what's yours is mine, and the other half will go off to brothers and sisters. Oh, sorry.
Okay. And on or after the 2nd of April, the Inheritance Guernsey law. I think it simplifies, well, it simplifies the law quite considerably. Different scenarios to look at. I think we'll put down 4 scenarios. So surviving spouse or civil partner only, surviving spouse, civil partner, descendants, and then when you've really got a collateral succession where you've got no surviving spouse, no descendants. Surviving spouse only when we're talking about immovable. That's 5 by 28 days, which sort of makes sense to me, but there you go.
And the reason for that is if you're both in the same car, you don't want all the assets going to the one who limps on for the next 6 hours. So you've got to survive for 28 days.
And in that case, they
get the lot, which is what I think most people nowadays would expect.
Yeah. Surviving spouse and descendants, slightly different there. You've got to classify the matrimonial home, and there's definition of matrimonial home in the 2011 law. They get half of that, absolutely. Half of, let me get this right, any other realty.
Yep.
To say that. A usufruct of the remaining bit of the matrimonial home. Until they're married.
Until they remarry.
Yeah, until they remarry.
So basically, half goes to the spouse,
Yeah.
half
Half
goes to
to
the kids, but the kids have to acknowledge that mum or dad are entitled to remain in the whole of the matrimonial home, not just the half that they own absolutely. So you can't kick your mum out, nor can you insist, as some families genuinely insist they pay rent on the other half.
Really?
Yeah.
Oh, okay.
Yeah.
I know that.
Typically the Western parishes.
That doesn't mean anything to me. Not yet. Okay.
Presumably the children.
Yes, they do. Yeah, absolutely.
And again,
yeah.
representation is
Yeah.
permitted.
Yeah.
And from now on, under the 2012 law, 11 law, representation is always allowed.
Yeah.
You don't have to worry about this thing about only if a brother comes to join in the estate.
Descendants only, or kids only, they get the whole lot. Again, representation, history of his distribution. Oh, yes, collateral succession. Well, we've got brothers and sisters taken first, then ascendants, then other heirs. So it's sort of like it was before in that respect,
Yes.
isn't it? You know, the class of persons who can take.
It's consistent with the customary law.
Yeah.
Goes
Although,
down generation, then you get brothers and sisters who are like privileged collaterals. Then it goes, and you get, and of course, with representation, you have nephews and nieces within that class of privileged collaterals. Ascendants, then, and it's only if you have no ascendants that you start looking for your second cousin twice removed.
no distinction between props, etc., which makes life a little easier, I think.
Yes.
Movables, yeah, okay.
I should say that there is now no distinction between children of the half blood and children of the whole blood. And in an estate that I think Paula was around in our firm when this happened, that caused all sorts of problems because we had a Guernsey domiciled man who passed away. His father had abandoned him when he was 6 months old, and his mother. This chap had been brought up by his mum. Meanwhile, the father had begat a whole load of children from various mothers across Northern Ireland, none of whom knew of the existence of the Guernsey gentleman. And when it came to looking at who were the heirs for the real property of the chap who died in Guernsey, obviously the siblings, his half brothers and sisters from his father who had abandoned him when he was 6 months old and who didn't know the existence, they ranked ahead of his mother in the estate. So she got nothing and the estate was given to people who were strangers.
How did they come up with it?
You have to find it. Yeah. And it took about a year.
Where you have no knowledge.
You advertise, etc. They do tend to find through the work, don't they?
Yes, exactly. Title research and people like that.
Movables, I think we're looking at. Okay. Different scenarios again. Surviving spouse only. They take the whole lot. With descendants, it's half and half. Descendants only, they'll take the whole lot. And no spouse, no civil partner, no descendants. Oh dear me.
That's the same.
That's the same bone of account.
So it's collateral heirs, and if none within 6 generations, degrees of relationship, then it goes crown. The only difference between movable and immovable is this business about having a usufruct over the half of the matrimonial home that you don't take absolutely. because most families, you know, the matrimonial home will be a big chunk of the family
Yeah.
wealth. So now we are in Alderney, and we are looking at the completely different regime. I told you that Alderney changed their laws in 1949. So their regime is completely different. In essence, if you die intestate as to your Alderney real property, the property vests in the Court of the Clerk of Alderney, and they then have an obligation to dispose of the property.
So you haven't got a more sort of.
You
well, or does it?
You do,
but it goes to the clerk rather than to the heirs.
So the property vests in the heir, in the court, in the clerk of the court.
God. Yeah.
Correct.
Yeah,
they
yeah,
have
they
12
are,
months.
yeah.
But in as per the rule.
Yeah.
So basically, the clerk of the court has the property vested in them, and she or he has 12 months to dispose of the property. Now, if there is only one heir entitled to the property, and we'll look in a minute as to who the heirs might be, then that heir can come to court and say, don't dispose of the property, give it to me. If there are, and the court, if the one heir makes that application, the court is obliged to transfer the property to the one heir. If there is more than one heir, and they come to court and say, don't sell the property, vest it in me, the court has a discretion as to whether or not the heirs should inherit the property or could be given the property. So the court could still overrule the heirs and insist that the clerk of the court sells the property.
In practice, what do we do?
So in practice, if the land is agricultural land, the court may well require the property to be sold rather than vested in more than one person. And the reason for that is, as we discussed in relation to Sark, the island is tiny. We do not want parcels of land to become ever smaller and unviable in terms of agriculture. So if it's a farm, that farm may have to be sold. Remember, it may be sold to one of the heirs, but it's sold to one person to keep it together as one economic unit.
If neither heir wants
Then it's disposed of.
So
the presumption is anything that is inherited on a necessity will be sold unless somebody intervenes to stop that process.
Presumably, if you want to stop the process, you pay the market price or whatever.
You don't have to. No. So if you're the one heir, there's only one person entitled to the property, then the court will give it to you, and there's no money changes hands. If there's more than one heir, and you say, I would like you to transfer this property to this hotel, say, to the three of us, and we're going to run it, the three of us together, then the court may well give you the hotel. Again, no money changes hands. If it's a farm, depending on the size of the farm, the court might say, okay, well, you can have that field and you can have that field. But it is more likely to say, I want this farm to be kept together. The best way of keeping it together is for it to be sold. And you as an heir might want to bid for it. And if you do, then the more you bid, the greater the amount of money that is shared between the other heirs.
When you say bid, that kind of
auction. rather
Yes.
than a sale on
It's
Auction sale, isn't it, I think?
the sale should be by public auction.
So you can have a situation where you have a family farm where one of the family, say three brothers, one has worked the farm.
Yeah.
Was in the testing.
Yeah.
And that farm, even though he wants to retain it, it still has to go to the auction. So
He may, so they can apply. So in that situation, depending on how dysfunctional the family is, if I'm the farmer who is farming the farm, somebody else is a librarian in Birmingham, and somebody else is running a dive shop in Tahiti, I would say, I will take this on, and I will buy you out. But don't, for God's sake, because I know that my arch enemy, the farmer next door, would really like to buy my farm and put me out of business. So I would say, I'm going to apply for this to be vested in me, and can you guys confirm that you are happy that it's vested in me? In which case the court is likely to make that order. And I can sort you out separately.
And that happens all behind the scenes. It's not going to be interested in a separate arrangement.
Correct. All the court wants to do is keep this farm as one viable unit. I should say that in order to make this application to the court, you need to be more than 20 years old. Now, the age of majority in Alderney in 1949 was 20. It has now been brought down to 18, but that's the law has not been changed, or the law hadn't been changed until 2016. So you still have to be 20 to make this application.
So that wasn't expected to change.
No. So then, who are the heirs? Well, if you have a surviving spouse and no children, then the surviving spouse is the heir. If you have descendants and a surviving spouse, then again, it depends whether the surviving spouse has a right of douar or franc veuvage. So let's say the property is sold, and you're now sitting, instead of sitting on a house, you're now sitting on £100,000 worth of cash, and you have a surviving widow who is entitled to douar, and you have some children. You would give 2/3 of the cash to the children, and the other third, the £30,000, would sit in a bank account or be invested by the clerk of the court, and the income generated thereby would be given to the widow. And then when the widow dies, then the £30,000 capital, as hopefully appreciated somewhat, would then be transferred to the children. Equally, if you had a widower who was entitled to franc veuvage, then the £100,000 would be invested. He would get the income of £100,000 until his death or remarriage. And if he died or remarried, the £100,000, hopefully as an increased as a result of investment, would then be passed to the children.
If he's got no children.
So if there are no children and he's the only surviving spouse, then they give him the £100,000. Right, and if there is no surviving spouse and there are no issue, then after that, and this is contrary, this is completely contrary to customary law, it goes to parents.
Rather than looking for nieces.
Correct. So parents rank ahead of your brothers and sisters, or they did in Alderney. And then it was the brothers and sisters of the whole blood who ranked ahead and excluded brothers and sisters of the half blood. So it wasn't a case of brothers of the whole blood would get twice as much as brothers of the half blood. If you had a brother of the whole blood, he got everything, and your half brother got nothing. Okay, and so then, and again, there is no logic to this. The next class of heirs are your grandparents. And then after the surviving grandparents, it goes to your uncles and aunts of the whole blood. If you haven't got any of those, uncles and aunts of the half blood. Then if you haven't got any of those, it goes to the crown. So basically, none of the principles of customary law were respected by what they did in Alderney. But I imagine the law was written by an Alderney person who had lots of wealthy grandchildren and children who wanted to make sure that he got a look in before anybody else. I don't know that. That's just a pure guess. Okay, so then, and again, this is because if we look now at intestate succession to Alderney movables in this period before 2012 and after 1949, or actually after 1930, we have this bizarre situation that if you have a husband die, his wife, before 2012, yeah. If you have a husband die,
no, it's not. It's 2016.
Sorry.
Yeah, there's so many days.
1st of January 2016. Sorry. Husband dies, then his widow gets a third, and the children get 2/3 in exactly the same way as you would get in Guernsey. However, if the wife dies, the husband gets absolutely nothing at all, and everything goes to the children.
No children.
If you've got no children, then it
go
goes to
to
Ake. So you calculate who would get what according to Ake. The brothers and sisters, and then the parents, and then the motor husband is completely screwed.
Well, we have that happens.
Go sisters, go sisters. But this would all have been fixed in 1949, but nobody thought that it was worth doing.
Really?
Yeah.
New law.
Yes. Anyway, so also remember that the 2006 law reform law that applies in Guernsey did not apply in Alderney. So whereas the 8th of May 2008 is a key day to remember in Guernsey, because that's the day when illegitimate children were then treated as if they were legitimate, that did not apply in Alderney. So until the 1st of January 2016, if you had an intestate inheritance in Alderney, your illegitimate children would get absolutely nothing. They would be out in their ear with the widower. Sark. So Sark rules of inheritance, intestate succession, as we've already seen, until 2000, the 19th of January.
I think it is, yeah.
You couldn't have a will of Alderney, of Sark land. It devolved in accordance with customary law, but they tweaked it a bit. So, if you had a son, regardless of the order of your children, you could have daughter, 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 son. The eldest son would inherit your tenant-in-law. And if your son had predeceased you and he himself had left a son, your grandson, no matter how infant, would have trumped your daughters.
Does grandson trump any other son?
Eldest grandson, yes. So eldest son of eldest son
will
trump
trump.
second son.
Yeah.
And again, this shows you the Norman idea. You push it down
Yeah.
generation as far as it can go. If you had more than one tenant-in-law, the eldest son got everything, to the exclusion of his younger brothers and all his sisters. If you had daughters but no sons, the eldest daughter trumps her sisters. And again, that's contrary to customary law, because in customary law, all girls need to be treated the same. But they didn't do that in Sark. So this was a quirk of Sark.
If presumably, I think I know that, but if eldest son dies with no children, but there is a second son steps into
Yeah.
Correct.
Even if daughters have sons.
Correct.
Elder daughters have sons.
Correct.
No, sons are always
Oh,
preferred.
sons will always get.
Not very fair. But these rules apply.
But it's preserving the family, isn't it?
Keep the family name. Now, if you didn't have issue, then the rules that we've already talked about collateral succession to Guernsey real property would apply. So all that stuff about Proc and Acquet would apply. This is before 1999.
You mind if I ask a tangential question? Sometimes I refer to issue as opposed to children.
Yep.
Yeah. Yes, there is.
So
Yeah.
what's the difference between children?
So issue is a wider term, and it includes your children and remoter issue. So it's your
Grandchildren,
great-grandchildren,
great-grandchildren,
great-great-grandchildren.
Yeah.
And when I draft in a will that it goes to their issue, I will then say brackets, children and remoter descendants, those brackets. Make that clear. And remember that you had Douai and you had Frank Vauvage in Sark before 1999. So those are the old unfair rules.
These are now the new unfair rules.
That relates to your real property.
That is
Yes,
your real
that's
property
correct.
in Sark before 1999. So after the 19th of January 2000, we had the Real Property Succession Sark Law 1999, which really kick-started the reforms that we are now seeing in the rest of the bailiwick. In terms of intestate succession, it abolished this notion that boys were better than girls. Because the land still must remain indivisible, you still need to pick an heir to inherit your Sark land. So it's now just the eldest descendant, male or female. And it's only if you haven't got any descendants that you then look at what we call the privileged collaterals. So that's your brothers and sisters and their issue. And then we go up to ascendants. Again, ascendants only inheriting from the last of their descendants. And if you haven't got any ascendants, and you haven't got any brothers and sisters, you haven't got any nephews and nieces, then it goes out to your remoter cousins. If you haven't got anybody within those classes, then the seigneur in Sark takes the land. Again, this is all subject to the new Section 11 life interest rules in favour of a surviving spouse, which have replaced Douai and Frank Bavage. So it's the third. Life interest over a third. And then just to finish off with Sark, personalty on an intestate succession is exactly the same as you would get in Guernsey. The 1975 law is the same as the 1930 law in effect. So if you have a surviving spouse and you have issue, then regardless of the gender of the surviving spouse, they will receive a third, issue will receive 2/3. If you have no surviving spouse but you do have issue, the issue will take all of it.
And you're doing the issue there, you know,
Children, grandchildren.
So children. No. So issue there. I mean, children, and then if any of your children have snuffed it before you, and they have left grandchildren, the grandchildren step into their shoes because you get representation. If you have no issue, but you have a surviving spouse, then half of the personalty goes to the surviving spouse, the other half goes to the collaterals, the brothers and sisters, and their issue. And if there are none, then to the parents, and if there are none, then to your remoter cousins. And if there are none, then to their issue, and if there is none, to the seigneur. So you can see why intestate succession is more interesting to ask you questions about than testate succession.
Right, I've got long left. I think probably the best thing to do is to set up the questions for tomorrow.
Yep.
People will have a look at them. Let me just. Oh, it doesn't matter. No, well, if you haven't, no, it doesn't matter. Doesn't matter. Doesn't matter if you don't have a chance. Fine if you don't. Fine. What have we got here? I want to have a look at some past papers. So let's just sort of tell you the questions that I've looked at. So they're completely arbitrary, but they're questions that we can answer. But they're in no particular order. May 2010, question 5. Then you want to jot these down. Sorry, sorry.
May 2010.
May 2010, question 5. We'll kick off with these, I think. April 2015, question 2. I don't know what they're about now. September 2012, question 2. Yeah, sure. May 2010, question 5. April 2015, question 2. September 2012, question 2. And there's a few more. May 2010, question 4. Clearly looking at the same paper version. And April 2015, question 3. There are others, but those are the ones that I looked at. April 2015, question 3. You should be able to have a go at those. If we get a chance to do any more tomorrow, we shall. But what I know, but what I desperately wanted to do is trust law. Because we've not really, we sort of tangentially looked at trust, but there is material in the guide on trust. To be honest, a lot of it is, I tend to think, English law based. Yes, thank you. So therefore, if you know English trust law, I mean, there are differences, and we'll highlight the differences. But you know,
yeah,
a lot of it's very, very similar to English law.
So the reason why I don't think you see many questions about trust law in the Guernsey bar exam, I figure you're already a British qualified lawyer. You must have done some trust at some point in your life, and our trust law isn't that different.
Oh, is that what you think?
I think so.
Yeah.
Whereas you do get lots of questions about our laws of inheritance, because they are
very different.
Very different.
Yeah. So I was going to look at the worksheets and have a look. There's a couple of problem questions on those worksheets that I was going to look at. To be honest, on worksheet 1, I think it's pretty similar, pretty simple. And it's things like, you remember the old 3 certainties in English law? Is that stuff? I tend to call it Guernsey. And then the other one is just a client coming to see you and asking for advice because he wants to do various bits and pieces. And I think it's concentrating primarily, if I'm not mistaken, on knowing your client, because you don't know him, sorry if that makes sense. So it's sort of going through know your client things, which I don't think is in the guide, but I thought we ought to have a little chat about.
Yeah.
And also discretionary trust in the main, because I think what you're going to do is largely do it with the discretionary trust and letters of wishes and protectors and things like that.
Yes.
So what I can recall. So I really want to concentrate on things like sham trust, which we don't tend to do in English law, protectors, which again, if you've done English trust law, you don't know what a protector is. An enforcer, I like the enforcer because that lets you do something that you can't do in English law, sort of. Yeah. Where? Yeah, sort of.
Depends if you believe Mr. Baxter Walker's book.
So I want to have a look at some of the different sort of things. Reservation of reservation of powers. I want to have a look at as well, because the first time I came across those, I had apoplexy. I must confess. So I thought, my God, tax, which I think is probably what you thought as well. So I do want to have a quick look at anything that's different in the main, I suppose. We want to concentrate on tomorrow, because we don't have time to concentrate on the whole lot. Okay. We are starting at, I don't really mind, 10 o'clock, and I don't really mind. I've got a taxi coming to pick me up at 1 o'clock, so we can go till 1 if you want, or we can go till 12:30. 1, yeah, I'm perfectly happy. Oh, sorry. No, we can't, can we? Because it's not open, I don't think. I think that's the problem. We can't come in at 9. Otherwise, I don't mind.
We were standing outside.
Yeah, we were standing out this morning, so. No, we'd arranged to meet and
chat to make sure.
But we were singing the same, but we were just stuck outside. So I think if we try and make it earlier than 10, we might be stuck outside. That's the problem. Which I don't think any of us really want that. So make it 10, and we'll go through till 1 o'clock. I'm happy with that. If everyone else.
And are you flying out tomorrow night?
I'm flying out tomorrow afternoon. I can't remember what time my flight is. I'll be back in Birmingham at 7, but it's not straight back to Birmingham. It's from Jersey, is that one? Yeah. So I can't remember what time it leaves Guernsey. It must be about 4-ish from Guernsey. So that's fine. I mean, 1 o'clock, absolutely fine. I'm not bringing my bag here. He can take me down to pick up my bag. I'm not bringing a bag. Absolutely not. No.
Do you want me to pick you up tomorrow morning?
Yeah. Oh, no. It's good for me. It's good for my soul. There's nothing else. It's good for my lungs. It's good for my soul. No, thank you. Oh, machine. Yeah. No, we
I didn't realise this